My Lord the Chief Justice and members of the court, in answering the three questions that was posed by the court, I'll begin by saying that the 2013 Constitution must be obliterated. The point raised by Justice Young yesterday was on point, and his lordship was quick to say that here we are dealing in Prasad and in Garase with a usurping government. What we have here that's currently in government is not a usurping government. It is the legally effective government, and it would be inherently nonsensical for the legally effective government to choose a remedy alternative to Section 91(5) to come before your lordships to invoke the jurisdiction of this court. The party leader for my client, who is also the Prime Minister of the legally effective government, has signed off on these questions, and I submit to cooperate for convenience. Or as Ms. Rekadi said, under duress. Dr. Butler said it pointedly in saying that it is that Fiji was handcuffed. There is a saying in Fijian, and I quote, "Dengai tu naini malub nawanga." Your lordships just sit with your arms folded while the canoe sinks, or cabinet sits with its arms folded while the canoe sinks. Choosing an alternative remedy when the constitutional remedy under Section 91(5) was there, to use would be to let the canoe of our state sink under the weight of an illegitimate constitution. This cooperation for convenience, however, must not be mistaken for acquiescence. We come before you not to tinker with the rigging of a sinking ship, but to ask you to condemn the hull. The hull itself needs to be condemned. Cabinet has used the procedure under the 2013 Constitution precisely, and we argue that the entire instrument is void, and to invite this honorable court to perform its deepest duty to restore the rule of law by reviving the lawful supreme law, the 1997 Constitution, which your lordships and your ladyships own jurisprudence in Fiji, in Prasad and Garase, holds was never lawfully abrogated. This leads me directly, my lords and my lady, to the question posed by the court. On question 1, the power to withhold recognition. My lords, we agree with Justice French that the question 5E cannot be answered without dealing with the preliminary issue. And the preliminary issue is the question of jurisdiction. But we'll say this court possesses the ultimate power and indeed the duty to withhold recognition from any purported constitutional provision that lacks foundational legal authority. The authority for this is Prasad. The doctrine in Prasad, my lords, established that a revolutionary regime must satisfy specific conditions to abrogate an existing legal order. The 2013 Constitution fails the test. It was not enacted under the lawful procedures of the 1997 Constitution it purports to replace. Therefore, its provisions are in law nullities. The current government's democratic mandate does not cure this original defect. It makes the need for a cure more urgent. On question 2, my lords, recognizing the whole but invalidating a part, of course, your lordships cannot rewrite the Constitution, but the premise of this question is flawed, my lords. The court cannot recognize the Constitution as a whole if the entire edifice is built upon an unlawful foundation. The provisions we challenge the preamble, we challenge section 2, we challenge section 158, we challenge 1734, we challenge 159 and 160. So these, we say, are undemocratic. They are mechanisms that were designed to entrench an unlawful overthrow. To sever them would be to perform surgery on a corpse. The only logical conclusion compelled by Prasad and Garase is that the 2013 Constitution in its entirety is legally ineffective and must be obliterated. On question 3, criteria for qualifying amendments provision, this question, my lords, with respect, presupposes we are dealing with a valid text. The only relevant criteria is the test of lawful abrogation from Chandrika Prasad. Was the 1997 Constitution lawfully abrogated? Garase holds it was not. There were unlawful acts declared, and the supermajority requirements of sections 159 and 160 are locks of the door of an illegal structure. This court cannot read down these locks. It must break the door down by declaring the entire structure unlawful. For these reasons, my lords and my lady, we urge this court to find, as a preliminary issue to question 5E, that the 2013 Constitution is void ab initio and of no legal force or effect. Therefore, the 1997 Constitution is valid and applicable, and subsequent to that, provide transitional provisions as the court deems just and effective in the circumstance. Thank you, my lords.
Thank you, my Lord Chief Justice. My lords and my lady, at the outset, I'll clarify or I'll state that the National Federation Party's position before this court is to be as helpful as possible. We are not wedded to one position. We have sat here and listened to the submissions of our colleagues and the very helpful submissions of Amicus this morning, and we've taken it into account. In some of we have already answered to a certain extent in our submissions in chief and in our reply submissions, the questions in the memorandum. But if we, with the permission of the court, if I may add briefly to that, in light of what we have heard in the court, As to question 1, the focus of submissions has been on, in the context of question 1 and Justice French's questions, on efficacy as it applies to the 2013 Constitution. But if one looks at Chandrika Prasad and the principles, efficacy applies to the revolution. It applies to the abrogation of the Constitution and to the establishment of the new legal order. In historical terms, that took place in 2009. The Constitution was promulgated in 2013, by which time the regime had been in place. So I invite the court to consider whether in that space there is room for the court to consider whether it is bound to recognize the whole of the 2013 Constitution, since, strictly speaking, efficacy is not a test for that Constitution we would submit. The alternative position which we have articulated in our submissions in response to question 2 is that, like the state, our principal submission is that the court can recognize the Constitution as a whole, but but treat a provision as enacted as invalid. Our argument was in terms of democracy and the principles that are guaranteed by Section 3, to treat the amendment provisions as inoperable. As to question 3, assuming that the court has power to qualify its recognition, what is the criteria? We would respectfully accept that the criteria is found if you go under approach 2, which is the states within the Constitution itself. And on either the extramural approach or the internal approach, we would support the application of customary international law principles, particularly that of democracy and, well, of self-determination. We accept, as the National Federation Party, that the underlying, that the provisions must be read as severable, and whether the test is whether it's inherently inconsistent with the underlying principles in Section 3 or of self-determination. We would respectfully submit that the other principle that must be applied is that in making a decision as to what to do with the amendment provisions, the court must balance rigidity with flexibility to meet the changing needs of the people. And we would, in conclusion, if the court so finds, accept the blue pencil approach, although we expressed reservations about the referendum. We accept that there does need to be that a 2/3 majority alone of the House might be too easy and undermine the concept of supremacy and would be an inadequate protection for the people. So we would accept, if the court so decides, a blue pencil rule that maintains the referendum, but by a simple majority without the 3/4, striking out the 3/4. Unless your lordships and ladyship have any questions, that is all.
Is that it?
Yes.
Thank you, Mr. Epworth. Over to Sodelpa. 10 minutes to you.
My lords, my lady, we are in support of the submissions made by my learned friend, Council for People's Alliance Party, except to be consistent with our submission, both written and oral, on the issue of abrogating the 2013 Constitution ab initio. In our submission, we have stated that it will not be proper for the court to abrogate the 2013 Constitution ab initio, because it will bring chaos to government. So what we are suggesting, my lords, my lady, that the court can preserve acts, administrative acts done under the 2013 Constitution to ensure and sustain the orderly running of the state. That is all, my lord.
Thank you, Mr. Ulundoli. Mr. Singh, Ratu's faction.
My
10
lords,
minutes to you.
Thank you, my lord. My lords, my lady, once the 2013 Constitution is accepted as the governing law, it binds us all. We've heard Mr. Moses how he submitted on the efficacy test. With the abrogation of the Constitution, the then government had total control of the country. Entire judiciary was dissolved and new appointed. People have accepted the Constitution, as we have had 3 elections with high voter turnouts. In totality, they had complete control and obedience from the people. The preamble itself makes it clear that we, the people, recognize this Constitution as the supreme law of our country. It is the very framework that governs not only the conduct of courts, but also every Fijian. Section 2.3 further reinforces this by requiring the Constitution to be upheld and respected by all, by citizens, by state, and by public officers alike. The obligation it imposes are not optional, but must be fulfilled, and this court must ensure this. There can be no exception, no partial compliance. There are clear paths in the Constitution, and the path laid down towards amendment followed, with open eyes and not closed one. The question of any suggestion of partial compliance is nonsensical and would cause mayhem and complete disorder to the legal system. Section 3 directs that anyone interpreting or applying the Constitution must do so in a way that promotes its spirit, purpose, and object as a whole. And so I respectfully turn to our own oath to uphold and defend the 2013 Constitution and the rule of law in accordance. With the greatest respect, if this court were to withhold recognition of a provision or treat a constitutional clause as invalid, we would be acting in contrary to the solemn oath. The duty is to uphold the Constitution as a whole and not in part. I now turn to question 3. With respect, the answer must be no, we cannot read down. The court cannot reduce or dilute a constitutional requirement simply because it's difficult to achieve. As Mr. Nandan said yesterday, an attempt has been made once and failed. That does not mean future attempts will fail. To decide otherwise would be to give an opinion on a purely hypothetical matter which would be premature. We cannot and must not allow our legal system and framework to be manipulated by political motives. The Constitution must be upheld in its entirety. Anything less risks drawing the court into a political sphere, as Mr. Moses highlighted. And any amendment must ultimately meet the test of people's referendum and the 3/4 requirements. A.V. Davis' doctrines states the courts develop common law principles to give constitutional interpretation, and Parliament makes law, amend them in accordance to constitutional requirements. What criteria to adopt? There is none. It has been 12 years in making of the Constitution. There has been no coup, no challenges in court apart from this one. The Constitution works. It's doing its job. Thank you.
Thank you, Mr. Singh. Honorable Naivalurua's faction. Got 10 minutes, Mr. Valalaburi.
I'll begin by quoting again the Honorable Prime Minister then, Mr. Rabuka. who is the Prime Minister today, because there is some discussion that this is a political question. This we differ with, my lords and my lady. The question is strictly legal. It requires legal clarity, and therefore Cabinet has now referred the question to the Supreme Court. I quote, "What will give legitimacy to our Constitution is the principle that it has been developed with the free and full participation of everyone. It provides for a system of parliamentary government based on the consent of the people. It is now the linchpin to these discussions, the issue of the informed consent of the people. The 2013 Constitution, the Honorable Court is invited to take judicial notice of it, and it has also made mention of it in the previous reference, that this is a constitution made by a handful of people, of officials. There was no consultative process. So, in the Republic of Fiji, legitimacy comes from the will of the people. And if we look at the test in Chandrika, though it's cumulative, though as my Lord French has indicated, this is common law, and this is the court that creates the common law of Fiji. Right now, there is only two tests, de facto or de jure, and that is the finding of the Court of Appeal. And in relation to question 5 of the Cabinet reference, that is the clarity that we believe that Cabinet is asking. We have a court finding here in Garase. How should we deal with it? Does it still inform our constitutional interpretation processes, or what is actually the position? The position that the G11 is putting forward, we want the country to move forward with stability and with legality. And we believe that Garase is a bridge back to legality. Now, we'll answer question 3 first, if I may. And I'll read for the listening public the question. Assuming the court considers it has power to qualify its recognition of the amendment provision, what criteria should it apply to determine the extent of its recognition of those provisions and the extent to which it reads down the supermajority requirements? Unquote. The G11 says, and we agree with the observations that has been made by Justice Young, that the court can take a judicial notice of facts on the ground in Fiji, including its historical development. Now, entrenched provisions in Fiji, the court is invited to make a comparison of 1997 Constitution and the 2013 Constitution. I will say that it is a fact that Fiji is a multiracial society, and it's made up of different ethnicity. Now, in the 1997 Constitution, as well as in the 90 Constitution, as well as in the 1970 Constitution, there are protections for indigenous Fijians in relation to their resources. It is now recognized in the UNIDRIP, in the ILO 169. Any changes to things that involves their traditional culture, their resources, and their society, it requires a 2/3 majority. And that relates to the Itauke Affairs Act, the Native Land Trust Act then, the Fijian Affairs Act, the Great Council of Chiefs. Now, that 2/3 majority, specifically in relation to indigenous Fijians, for any changes to it, you need 2/3 majorities from the bottom, from the House of Reps, 2/3 as Senate, and then 2/3 of the members of the GCC that are in the Senate. These protections is not in the 2013 Constitution, and it has already been applied in Bill 70. I invite the court to take judicial notice of Bill 17. Bill 17 removed the consent or the voices of the resource owners to have any say in the sales and mortgages of their land. This would not have passed in under the 1997. That is the entrenched provision that the G11 believe should be
4 minutes
adopted
left.
in relation to question 3. That my lords and my lady should answer both 1 and 2 as well. Thank you.
Thank you, Mr. Wagalal. For the Fiji Labour Party, 10 minutes. You may begin.
My Lord, Your Lordship, Chief Justice, my lady, and my lords. The way in which we have made our submissions to this court, through our written submissions and also from our oral submissions, is specifically based on the reference, where reference said the interpretation and application of those provisions. What we are invited to do now, as I see it, is to provide some sort of solution or middle ground. Therefore, our responses are to facilitate and assist this court in that aspect with greatest respect, to find the best of both worlds. Now, going to the first question, Your Lordship, Chief Justice, my lady, and my lords, our answer in summary to that is the court cannot withhold a recognition of a certain provision. We simply apply the efficacy test as very eloquently explained by the counsel for the Fiji Law Society, Mr. Moses. There's nothing more to say than that. The second question, Your Lordship, Chief Justice, my lady and my lords, the recognition of the Constitution as a whole, but having done so, to treat a provision of the Constitution as enacted as invalid. Our answer is no, that this court cannot do that. Now, to illustrate, I would refer to a case authority, Singh versus Prasad. That was a Court of Appeal decision where it has to deal with the issue that the decision by the Court of Appeal is final. Once this reached the Supreme Court held that the courts must give the priority to the ouster clause, as it is defined in the law. Now, the third question, assuming that the court has a power to qualify its recognition of the amendment provisions, what criteria it should apply? Now, the first question, before making our submission, my lord, that comes to our mind is that what criteria and who decides which criteria is it going to be? Is it this court that is going to decide the criteria? And that is where, as His Lordship, Justice Yang said, we need to find a democratic way. The democratic way, in our way, my Lord, is the people's way. And the criteria has to be decided by the people. Therefore, our answer to that question is no, that this court cannot look at a certain provision and recognize one and then look at whether what criteria should apply. This court doesn't have the power to do so. That's our submission.
Thank you, Mr. Karandan. For the Unity Party, 10 minutes.
Thank you, my lords and my lady. Our position is very clear to this court that the 1997 Constitution, which is the People's Constitution of this country. I'm sorry. I'll start all over again. Thank you, my lords and my lady. Our position, the Unity Fiji Party position, is clear to this court that the 1997 Constitution, which is the People's Constitution of this country, was not lawfully abrogated, which means that the 2013 Constitution is not the valid Constitution of this country. And I would like to just quote a little passage from Prasad's case to support my statement. And it says, however, in relation to proof of the popular acceptance of the abrogation of the Constitution or to the overthrow of the elected parliament or the forcing out of office of the president, the court would require full proof, full and proper proof. And then it quotes Mitchell's case, which states, Haynes P. said, a revolutionary regime should not be accorded legitimacy by this court unless it is satisfied that on the whole, the regime and the people behind it and with it, legality should be achieved only if and when the people accept and approve in them lies political sovereignty, and the court so finds. This approval they may give ab initio or subsequently. Length of time might or might not be sufficient to infer it. It might be expressed or tacit approval, but it is that which should give legitimacy to a successful and effective revolutionary regime. The support of a real majority is sufficient. This could be shown by its majority vote at a general election or a referendum or a majority percentage at polls. In court, it can be proved by agreed statements of fact or by affidavits, and these modes are not exhaustive. If a constitution was abrogated, a new one should be substituted forthwith, as happened in both of those cases, that is in Valabachi and Matov case. And such an onus cannot be discharged without proper affidavits or an agreed statement of facts. It is insufficient for a court to have to rely solely in deciding such an issue on the taking of judicial notice of notorious facts. Haynes P. concluded at 73, I do not think this court can properly act on a bare statement of fact or opinion of popular support, however credible and eligible the source is, and whatever is the basis of it. Proof of the fact by judicial notice may be admissible, but the weight to be given to it is another matter. I would hold that what is needed here is proof of particular facts or circumstances from which the court itself can infer popular support. In my view, the proof here was insufficient. And then in Mokoso case, Cullinan CJ was prepared to accept an affidavit from the Attorney General deposing that the laws promulgated by the government were enforced and obeyed throughout the kingdom, and that the decisions of the courts were enforced by the government. The efficacy of the change was marked by the acceptance of the people, which acceptance was spontaneously popular, unqualified, and widespread. My lords, and my lady, if I may just complete my submission with reading of the Court of Appeal judges stating this in their judgment in Garcia, at page 40 of their judgment in the Garcia case. This is what the 5 judges said in the Court of Appeal. The 1997 Constitution was made in Fiji, for Fiji, by the Parliament and people of Fiji. It contains many of the rights and freedoms mandated by international instruments. It protects the rights of the indigenous people and entrenches some of those rights. The extensive consultation undertaken by the Reeves Commission that preceded its adoption in Parliament provides strong evidence that the 1997 Constitution reflected the will of the great majority of the people of Fiji. It is permissible, when assessing the test for efficacy in this context, to take into account the evidence which suggests contentment with or acceptance of the 1997 Constitution by the populace at large. Such acceptance militates against the proposition that there has been general acquiescence in its abrogation.
You have 5 minutes left.
All right, my lord. In formulating our understanding of the common law of Fiji on the efficacy question, we are conscious that we are sitting as judges of a Fiji court. Consequently, statements by judges which may have been appropriate for other countries where a revolution may have come about in a variety of ways need not be adopted here. Thank you, my lord. And having said and read what I have read and informed the court about, we offer no comments to the question arising from the 2013 Constitution. Thank you.
Thank you, Ms. Rakadi. Over to the Fiji Human Rights Commission. 10 minutes.
Thank you, Your Lordships and Your Ladyship. We actually had responded to these questions, but we would still like to utilize this opportunity. We wanted to expand on 2 a bit. If I repeat our answers yesterday, it was yes and yes to 1 and 2. And in terms of 3, we insisted, requested, maybe we prefer insisted, that human rights be an essential component of this criteria. Now, we've been hearing reference, and rightly, legally, to the time factor and elections to demonstrate the legal effectiveness of the Constitution. But I think in the case of Fiji, and it's in our written submission, we need to look back at Fiji's constitutional history. And for the benefit of the public, I want us to go to the 1970 Constitution, which was the Constitution that survived the longest, 17 years. And under that Constitution, there were 4 elections held, 1972, 77, 82, 87. Then abrogated by the military coups. There were 2 successful military coups. Then the imposed 1990 Constitution came into effect and survived for 7 years. 2 elections held, 1992, 1994, amended and repealed by the 1997 Constitution Amendment Act, which suffered in its 12th year, well, I think in respect to the People's Alliance and to my learned friend in Unity, purported abrogation. It had 3 elections, 1999, 2001, 2006. Now, the 2013 Constitution is in its 12th year, 3 elections held, 2014, 2018, 2022, and the reason we are here is because it's now facing issues with its legitimacy and efficacy, and is now involving 2 fundamental critical institutions of the state, Parliament and Cabinet, and the judiciary. When we look at these 2 factors, the time factor and elections in the context of Fiji, from the Human Rights Commission, we consider that these 2 factors alone are not enough to determine the legitimacy and effectiveness of a governing regime, and this is why we would plead with your lordships and your ladyship that a significant concern that we face now is the ongoing acceptance of the people concerning this constitution. Yes, I respect the argument that we've had 3 elections, the time factor, look at the time factor, it's over 10 years. But when we look at our constitutional history, the time factor and the elections are not sufficient. There are other considerations that should be taken into account. And a primary consideration is the ongoing acceptance for this constitution by the people of Fiji. And in particular, I will mention an institution that no one has ever mentioned, and that is the military institution. That the military institution should now know that its role is to be a professional institute and to keep itself subordinate to civilian rule, because they have been a source of a fundamental and a great problem in this country. And I think, your lordships and your ladyship, I should stop there. Thank you.
You still got a few more minutes. You don't want to take it?
Well, if I have a few more minutes, I will emphasize...
Can you address the issue of minority rights? Only 2 minutes, not just a general statement. Address the issue of minority rights.
You got another
Yes.
5
The
minutes.
indigenous people are not the only people in this country.
In terms of human rights, we have mentioned the individual right of self-determination. We've also mentioned the group rights, particularly as pertaining to the indigenous community of Fiji, in terms of their self-determination, the group right, and the right to free, prior, and informed consent. And we've also, in our written submissions, we took care to also point out that these rights does not mean disrespect or the violation of any other rights of the minority groups or other communities or migrant groups here in this community. Your lordships and your ladyship, if you would look at our written submissions, we particularly also emphasize protection and preservation for the rights of every other community and migrant groups, including distinct privileges that accrue to their special status within Fiji. We did make acknowledgement and recognition of that, Justice Mathetong. Is there any other?
No, thank you, thank you.
I apologize if I became a bit...
No, you got another
Too
4
strong.
minutes. If you want to stop.
No, I think, Your Justice, I think that it is best that I think I've made more than sufficient impact. But before I sit, if I could just again prevail upon your lordships and your ladyship, that significant consideration, what is the ongoing acceptance for this constitution in relation to the public?
Right, thank you. Over to the Fiji Law Society.
Yes,
10 minutes.
well, Your Honours, I won't be that long. The only issue that I wanted to revisit is question 3, which is the criteria that the court should apply to determine the extent of its recognition of the provisions and the extent to which it reads down the supermajority requirements. One of the most authentic constitutional mechanisms for self-determination is a referendum, and it was illuminating during the debate between Amicus and the bench, and in particular the exchanges with Justice Young, where there was a reference to what should be the percentages in relation to a parliamentary vote and the referendum. And Your Honour, Justice Young delivered a figure, I think, of 2/3 for the Parliament and 51% for the people in order for there to be change. Now, Your Honour may have good reasons for stating those percentages, but there is no underlying rationale or reason that one could say that that fits what could be said to be criteria by which this court, constituted as a court, could in essence rewrite the Constitution.
Well,
And-
I'll just explain it to you. Those figures are figures that were simply the basis of discussion. That the underlying point of the discussion is to, I suppose, identify a line of reasoning which would start with Article 1.1 of the ICPPR,
Sure.
would ask whether the current amendment provisions satisfy the right of self-determination.
Sure.
If the conclusion is they don't, then the Article 1.3 obligation kicks in and applies to us, and it would be material to a rule of recognition, and we would, on one view of it, then be invited to recognise, as it were, fill the gap if we don't recognise the validity of the current provisions. Now, what happens if non-recognition leaves a gap is obviously a matter of debate. I think the state position is, we just do it by a simple majority. I'm not sure that that's, well, Mr Walker shakes his head, so perhaps it's not, although I thought he qualified by that, but we never would. And
Well, yes, that was his promise
so
on
we'll
instructions.
hear his reply in due course, but
Your Honour, I think the issue that we all confront here, with all due respect, is that this court is restrained in its role from being the adjudicator of existing rights and obligations as distinct from the creation of rights and obligations, because that's where you shift from judicial power to non-judicial power.
so where would it shift from? If we said we don't recognise it, should we stop there?
Well, that's the problem, you see. If you take that position, then you are in effect making this Constitution something that it is not.
At that point, we're simply throwing a spanner in the works.
No, you're not.
Which is probably not very helpful.
No, well, you wouldn't do it because you would be changing the Constitution into something that doesn't have a mechanism for it to be changed. So you're not going to do that. That, in effect, is a self-eating snake. So you're not going to do that. That's just, with all due respect, no doubt, Your Honour, an exchange that Your Honour's having with me to test my argument. But part of the role...
Sometimes when the court interprets
Yes,
a constitution,
yes.
they basically change the wording of the constitution.
It doesn't change the wording Constitution. It properly
Well, I've
construes.
seen some constitutional review cases where they've done that.
Yeah.
So the point, what is the difference between interpreting
Yes.
and amending?
Because, Your Honour, it's a good question, Chief Justice, because when you are construing the Constitution, you are giving, in effect, the interpretation of the proper meaning of the Constitution taken from its text and the surrounding circumstances. But when you then proceed to insert your own words into the Constitution, and here it's very stark, change 75% to 2/3, you are radically changing it from what it is. And that is not your role as a court.
But
I apologise,
thought-
Chief Justice.
I thought Section 3 tells us if there's two conflicting interpretation, you must look at Section 3.
Absolutely.
One that promotes people's sovereignty,
Yes,
human dignity,
yes.
and freedom is the word used.
Yes, and you are absolutely right, Chief Justice, but that provision, for the reasons that I referred to yesterday by reference to the authorities, does not give the court, on any view of the authorities, the power to ignore a provision of the Constitution, because they are both contained in the same document, Chief Justice. And the problem becomes that the court is being placed into a position then where it basically is rewriting the Constitution, and it doesn't have the power to do that, and it should not accept an invitation to fall into error to do that. It draws the court into a controversy, a political controversy, undermines potentially its authority. Part of the role of law society is to promote the rule of law and defend the judiciary. And the problem is, the court goes down that path, it will then be, in effect, writing the terms of the Constitution, taking away from the very people of Fiji their right for self-determination.
Sorry.
Can I just ask this?
Yes, Justice Arnold.
Let's assume for a moment that instead of 75%, the amendment clause said 90%. 90%
Sure.
of Parliament, 90% of
Sure.
in a referendum. There would then be no dispute, I think, that it would not be possible to amend the Constitution. So does the logic of your argument lead to the conclusion that therefore recognition should be withheld for the entire Constitution? Or would it be legitimate to say, given that impossibility of amendment?
Well, I think this is the issue that we've got to confront head on. Justice Young yesterday, when he and I had an exchange on Prasad, and he said it a number of times, I think, to a number of the council, elections signal a transition to a democracy under the aegis of a particular constitution. Now, we've had 3 elections in this country. Prasad, of course, the 8th criteria in the Prasad Court of Appeal judgment that I took you to yesterday, page 42, references elections as a powerful evidence of efficacy. Once you have one of those factors present here, and counsel for the state accepted the proposition that the efficacy doctrine applied, it's not a matter for this court based on, in effect, general propositions being put from the bar table as to what parts of that constitution it is going to withhold recognition from, and what is the principle by which it is to do that. The problem we have, and it was said quite eloquently, I thought, by Amicus, that you're not going to have a broad principle, so what is the principle? Nobody has articulated that.
I thought I had actually.
No, with respect.
The principle was that in applying the rule of recognition, the court will comply with Article 1.3 of the ICCPR and withhold recognition of a provision that withholds the right of self-determination from the people of Fiji. I think that is a principle. You may think it's a lot of bunkum, but I don't think you can deny that it is a principle.
No, we've got to focus on what the current facts are.
Yeah, but you don't have that.
But you're moving
no,
away.
no, you don't have that.
That is the problem I have with your submission.
Well, that's the problem. Your Honours don't have that, because on the current facts, you don't have any trigger that would enable you to go down the path you're being invited to.
Well, just put a minute. Say that it wasn't 75%, as Justice Arnold has suggested, but 99%.
I think Justice Arnold suggested 90%.
Yeah, I know, but I've just made it more extreme.
Okay.
So
sure.
The Constitution is unamendable.
Yeah.
Does a court, in recognising the Constitution, have to accept that unamendability?
On the question of the efficacy test, is that what you're answering?
Yeah, I'm saying on Europe, assume all the other facts in this case are identical, the amendment version is 99.9% of all voters underlined with the words, and don't try and read this provision down. Okay?
Sure.
So that's the provision.
Yeah.
Would you say we would have to I bit my tongue yesterday before and didn't put an extreme example, but I couldn't.
I never
resist
noticed
it
you
now.
were biting your tongue yesterday at all, actually. So
Okay,
yeah.
all right. Well, anyway, what would you say? Would you say we have to accept it, or do we say the alternative is, well, we just don't accept the Constitution, don't receive the Constitution at all?
Then, well, the Cyprus reasoning might provide an exception, but this is not this case. You do not have.
No, we're trying to identify a principle.
Yeah, but and I'm telling Your Honour, there is no principle upon which you can act in this case in respect of that scenario.
You may have to watch this space.
No, well, Your Honour, the problem with comments like that, with all due respect, is that when Your Honour says watch this space, well, what is Your Honour referring to as the basis upon which the court would act? Because the parties need to be heard. If the court is going to develop a criteria which the parties have not been told about because nobody's submitted on it,
then
Well,
you're again
I
going down...
I have put it a number of times.
Well, I'll put it very forcefully, Your Honour, in this way then, if I may, and I say it respectfully, that in respect of what you're being asked to do here on the current reference is to adjudicate on this scenario. You have had a concession from the state that the doctrine of efficacy applies in relation to this constitution.
Well, you basically have a conclusion from me to the same effect, so we're not relying on a concession.
No, well, but there is no issue that efficacy means that this constitution should be recognised, and it has been. We've had 3 elections and numerous acts. That's the first proposition. The second issue is the state comes here. We've got to get back to the framework here because Your Honours aren't sitting as a constitutional convention. Get back to the framework of what this case is about. State has come here because they say it is impossible to amend the constitution. We went to the parliament, we had a vote, and we lost by 1, and therefore we need to come here to get this change, to change this, in effect, from a referendum where both the parliament and the people get to vote on the change and give that power to the parliament only. That's what they've come here to say. So we've got to be careful what we're doing here. And then we know from the position that's been put by the state, they say, we want the 51%, that's what we want you to do, but we promise on instructions we're going to put a bill before
I'm not
Parliament.
worried about that.
Well, Your Honour should be.
No, sorry, I'm not worried about that. I don't see that concession as answering the fundamental problem that 51% in Parliament's not enough.
Sure. So the scenario here is the conditions haven't been met for this court to go down the path, if it wanted to develop as part of the common law in Fiji, some new principle of partial recognition. And the reason I caution and the reason I relied on your words, Justice Young, is if you go to page 42 of Prasad about elections being a powerful evidence of efficacy, your words yesterday, that elections signal a transition to a democracy under the aegis of a particular constitution, that's this constitution. Yep. So you cannot then pick and choose, once you've had that occur, what is going on here. Because what Your Honour is talking about is in effect a judicial review of the constitution back when it was promulgated. That's past now. So we have to be careful not to slip into any preconceived views about percentages in the referendum in order to create an artificial mechanism to do something that you haven't got the power to do and to draw this court into a controversy. That's all I'm asking the court, to take a step back and think about what it's being asked to do in the context in which it's being asked to do it. That's what we're here to do. Now, if down the track, and to pick up the Amicus's point, and I'll be more direct about it, if down the point there is an emergency, let's say after the next election, the government, even though it's gone with a platform to say we want to do this, and they don't get the votes in the parliament when they try this again, and there's some emergency attached to a particular part of the constitution that needs to be amended to protect certain rights or to do certain things, then that could create the climate to come back to this court. And the court can say that in obiter in its decision to give some guidance down the track. But prospective rulings, I mean, Justice French has referred to that principle. That comes from Ha in New South Wales. That's 1997, volume 189 of the Commonwealth Law Reports 465 at page 503. But the relevant part of that decision is just the caution again to the courts. You're here to adjudicate on existing rights and obligations. You're not here to engage in non-judicial power. And it's with caution you must go down that path. Because when you start plucking figures out of the air...
Mr. Moses, your time expired 5 minutes ago.
And you've been very patient.
Has been granted to you. Do you want another further 5 minutes?
I don't, actually. I don't, except it's only if the court has other questions of me, but I don't need to address you any further. I'll just end on what I started with. The most authentic constitutional mechanism for self-determination is a referendum. And that's where this matter starts and finishes. As to what those figures should be is not a matter for this court, no matter how wise it is, to pluck figures out of the air and say, we think that is appropriate, because you don't have the authority to do that.
Those are our submissions. Please the court.
Thank you very much, Mr. Moses. Dr. Butler, do you want your 10 minutes? Yeah.
Thank you, my lady, my lords. I feel I had a good go, so as to speak, this morning, but I've obviously listened and reflected on what has fallen from the bench and also what I've heard from the other parties. One proposition I wasn't able to get to just because of pressure of time was to get to the proposition that I think is inherent in what you've heard from Mr. Moses about how the court might think about the room for activity that sits outside of the Constitution. If we go back to the exchanges we've had today and yesterday, in a sense what the court is doing, if I can just use that term, is front-loading how to deal with what I've described as the conundrum. In other words, we'll take responsibility through the application of our rule of formulating a rule of recognition and apply that on the facts of this particular case. What you're hearing from Mr. Moses is that's premature. That point has not yet been reached, and that in a sense resonates with the point that I have made about not knowing quite how it is that what is it that needs to be changed? How is it that any new powers of amendment, so as to speak, might be used? One of the points I was anxious to make in my principal written submissions was about the possibility of what I refer to as non-violent extra-constitutional supersession. And I've given some examples from history. Some of them are about establishing a new order. That's how my country became the country that it is today under the Constitution of 1937, effectively the 1922 Constitution, which many people felt was imposed, was set aside over a process of 15 years. And a new process was used to establish the new constitutional order that had didn't tie back at all to any pre-existing legal authority other than the people. And the same is true of the example I've given you for the United States, how it moved from the Confederation to becoming the United States. But there was another example that I gave you which I thought might be of some interest, which is the example from France and how it is that France transitioned from an indirect form of election of president to a direct form of presidential election, which was a heavily contested concept in late 50s, early 60s France. And what happened was that in relation to that specific episode, a popular vote was taken, and the result of that, because it was significantly in favor of the proposal, from memory something like 58 to 42%, was regarded as, by those to whom it mattered, those who were going to give it recognition, the public, and the Conseil, this is my dreadful schoolboy French, Conseil constitutionnel, it was given recognition. Now, one of the points I've been at is that made when I was talking about extra-constitutional supersession is if you look at the Constitution, Section 2, subsection 5 is of some interest, I think, to the court when figuring out what room it might signal through any judgment it might give about saying, well, we won't front-load this, but we will recognize that there is room for others, perhaps, to look at aspects of this Constitution, or all of it, as not being permanently in stone. One of the poems I had to learn at school was Ozymandias by Shelley. It's great, because what it talks about is the statue of Ozymandias, this great ruler in the desert all alone. The plinth was indicating, look at me and my power, it's going to last forever. No, it doesn't. No constitution that purports to say this can never be changed can be taken bluntly, seriously by a court. Never would be. And that's
we
invited to take that view.
You're being invited to take that view intramurally. That's my point about going extramurally. So the extramural approach can I ascribe it to one of your lordships, if I may, just for illustration purposes, has been developed by His Honour, His Lordship Justice French, for example, how he might operate extramurally. But another which is the court taking the initiative, but another extramural approach is, in my submission, inherent in the terms of Section 2, subsection 5 of the Constitution. If your Honours look at that, what it talks about is it says this Constitution cannot be abrogated or suspended by any person and may only be amended in accordance with the procedures prescribed in Chapter 11. And the part I think I'm interested in just putting before your Honours for consideration, if you look at that Gaullist episode, is the Constitution cannot be abrogated or suspended by any person. Well, the people of Fiji are not any person. So what I'm trying to say is that Section 2, subsection 5 is itself, one way of reading it is it's an acknowledgement, implicit, but an acknowledgement nonetheless.
Does that fit with sections what does that fit with sections 159 and 160?
If you're operating intramurally,
No.
no. If you're operating extramurally, not a problem.
Of course, extramural action has tended to take a rather different course
And that-
here from the one that
indeed.
you've been discussing.
And that is why that is part of the conundrum or dilemma that I just ran out of time to confront, that faces the court, because the court might say, well, if we leave things to occur extramurally, what might that lead to?
Well, the articles recognise that over stringent restrictions set the scene in some instances
Correct.
for a coup.
And I was, and as your Lordship well knows, that's a key feature of my principal submissions when I talk about the dangers of unamendable constitutions. That's where I drew on the research that had been done by the Venice Commission and indeed others. What the Cypriot judges said in the Mustafa Ibrahim case, it wasn't vital to the result that they reached in that case in terms of necessity, but I did think there was some value, and which this is covered in my reply submission, to the commentary that those judges made about what I'd call the Ozymandias problem, pretending that you can just bake something in forever. So in response to the questions, it seems to me you're being asked to deal with this problem, either through taking the initiative through a rule of recognition, but is there another possibility available to you where you suggest that actually a process that truly reflects the exercise of public participation, the exercise of public will, that is something we would be prepared to
I'm going to resist
recognize.
the question I want to ask.
And again, these are just me putting ideas before the court to assist it in thinking around some of the issues that have been raised by my learned colleagues. They may provide you with other ways of thinking around the problem. They are, however, less immediate ways of dealing with the problem, and may therefore, the court feels, be unattractive in light of the way in which the matter has come before the court. But at the same time, the matter has come before the court in the context of the failure of a bill to amend the Constitution, but not just any old part of the Constitution, the very provisions we are debating here today. What might have happened if a different part of the Constitution, for example, when I was reading Hansard, there's reference by the Attorney General as to what parts of the 2013 Constitution might benefit from being amended. There were things like the Attorney General seems to have a lot of jobs to do. Well, is that something that could have been changed intramurally? that's what the problem is, then that needs to be
If
tested.
you want to change the roles of the Solicitor General, which would be faintly ludicrous to require a referendum with a 75% majority. Faintly ludicrous, entirely ludicrous.
But not necessarily difficult. Again, I'm just responding to what Your Honour says in terms of the proposition. But the answer that others might make is it's ludicrous to require a referendum on that issue, full stop, whether it's 75, 66 or 50. Again, that's just me giving an example of why the detail matters when it comes to these amendment provisions. And who's the right body to deal with that? Is that this court or others outside the court, with the encouragement of this court, the permission, for want of another term, from the court to look at that issue, but do it in the right way through a process that would reflect your animating principle of self-determination. Your Lordship, they were the points that I was going to make in the 10 minutes. That's helpful.
Thank you, Dr. Butler. I don't think the state would like to close now. So we break for lunch and come back and hear you.
Yes, please.
Sorry, what time? 2:30.
2:30. I'm in the court's hands. For my part, I'll be ready at 2 o'clock or 2:15 or 2:30, but I would not like to start later than 2:30.
So how long do you think you'll be?
It won't be longer than 2 hours, and it might be less.
2 o'clock. Okay, we'll start at 2.
Thank you.
So we'll adjourn to 2 o'clock and listen to the state's. Thank you.